Okay, welcome to Marriage Law, Practice and Procedure, Video 2. Last time we went through the history of favor of the faith cases. We're in Lesson 7 still, so we're still working on favor of the faith. Last time we completed the history of it. This time we're going to talk about the substantive law and the procedural law. So our document that we're concerned about is this 2001 CDF document called Potestas Ecclesiae. Okay. Now, you have a couple other sources too. There's a Kennedy article that I believe you have, which has, I think, a lot of useful information. Kennedy says, keep in mind he's writing in 2005, but he tells us that the CDF handles 750 cases a year on favor of the faith. He says that the fee is $420. Again, this is 15 years ago, so it's certainly higher now. And he also says that it usually takes the CDF about 5 months to review a case and to grant the rescript if it's going to be granted. Okay, I think that's not really essential things to know about the law, but certainly very helpful to advise your petitioner or your parishioner, rather, who may be a petitioner. We also had a reading from Hewells, and Hewells is very helpful because he very clearly lays out the two conditions for making a favor of the faith petition. So I hope you'll be able to read this. The two conditions. The original marriage is non-sacramental, so at least one of the parties is unbaptized. However, it may become sacramental. It may turn out that one or both receive baptism. If that happens, that marriage, that now sacramental marriage, this now marriage involving two Christians, it must remain non-consummated, or else you cannot petition for favor of the faith. So either a non-sacramental marriage, usually involving one baptized person, one unbaptized. If the second spouse, the unbaptized spouse, becomes baptized, that's okay as long as the marriage remains non-consummated. Again, this is if you want to petition for a favor of the faith. That's the first condition. The second condition is the petitioner, the one asking for the favor, is not the person primarily responsible for the breakdown of the marriage. The standard used to be the petitioner is not responsible. That's been modified a little bit now to say, or at least not primarily responsible. He or she at least is not the predominant cause of the breakdown of the marriage. Okay, those conditions. Who can petition? Who can invoke the favor of the faith? Now, this is in the McCormick commentary that I believe you have. Only the spouses. This is provided for in Canon 1142 and Canon 1697. Only the spouses can petition for favor of the faith. Whose faith is being favored? We used to think of these cases as only having a Catholic petitioner. So it was obvious whose faith was being favored. It was the Catholics. Now, though, we're sometimes going to have an unbaptized spouse petitioning. So what we're going to say, and that may be a petition to be able to marry a third-party Catholic, it can be for the faith of the Catholic party and of any child born to that couple. So it may not be, so it may be an unbaptized petitioner, but who was married to a non-Catholic Christian previously, but now wants to marry a Catholic. So in a sense, we're favoring the faith of someone who's not the petitioner, but who is a Catholic. Okay, so let's go through our norms. Again, recall the title of these 2001 norms, which are still valid, is Potestas Ecclesiae from CDF. And we have both substantive and procedural norms. We'll start with the substantive law. Article 1 discusses the conditions for bringing a petition. We've just discussed those. Hewells summarizes them very clearly, so I used Hewells for that. But Article 1 of the norms discusses them too. You have the norms as well. They were on the reading list, and I believe there was a link to them on the syllabus. Article 2, and this is described in the Kennedy article, Article 2 talks about how the CDF works. And one of the things they talk about is faxes. Essentially, a lot of the Roman offices don't really like faxes that much. They'll consider a fax valid for meeting a deadline, but they don't feel like they've really gotten the true document until they get the, quote, hard copy. The fax, in a sense, doesn't count for the really being the actual document. Okay, so Article 3, the essential conditions. These are going to be, we already just talked about the two main conditions that allow you to petition. These are some additional requirements to allow you to petition for a favor of the faith. 1, it is impossible to resume conjugal life. The marriage has really broken down. There's not really hope of reconciling. Also, as we said, this was kind of in our main conditions here. The petitioner, the one asking the favor, is neither the exclusive nor the primary cause of the breakup. Also, not only is the petitioner not the primary cause, neither is the new spouse the one who provoked the breakup. So maybe the petitioner didn't cause it, but the person he wants to marry was the cause of the breakup. That would not be a situation where the petition is granted according to Article 3 of the substantive norms. Okay, now we have a very important norm on the raising of children. This is Article 5. And what this says is that both spouses, both of the spouses entering into a new marriage, have to declare that they will baptize and raise the children as Catholics. So let's say there's an unbaptized person who was married to a Lutheran, and the unbaptized person now wants to marry a Catholic. He can petition, but he must declare that he will raise and baptize the children Catholic. And the new spouse has to do so too, the new Catholic spouse too. What's interesting is think about how that compares to an ordinary marriage under Canon 1125. Canon 1125 is the canon that has to do with a marriage with disparity of cult, and it also applies to a marriage between a Catholic and another Christian who's not Catholic. And what that says is that the Catholic has an obligation to try to raise the children Catholic, to do everything in his or her power, and the non-Catholic has to be informed of that obligation on the part of the Catholic. Canon 1125 does not say that the non-Catholic must agree to raise the children Catholic. Why is that? But look at Potestas Ecclesiae, Article 5, very clearly says that you do, in this realm of favor of the faith, you do have to agree to baptize and raise the children Catholic. Why this difference? Why is Canon 1125 less demanding and Potestas Ecclesiae Article 5 more demanding? Well, the reason for Canon 1125 you can find in the Vatican II Religious Liberty document. We're not going to require the, say, Jewish spouse to promise to raise the children Catholic, because we have to take account of the Jewish spouse's religious freedom too. And remember, raising a spouse in your faith, that's that's a duty. That belongs to natural law. That belongs to the education and rearing of children. So we're actually talking about a natural right as well. So Canon 1125 just says that the Catholic has this duty to try to raise uh, the children Catholic, not just to try, but to do everything that he or she can, and says that the non-Catholic spouse has to be informed of that. But Potestas Ecclesiae, Article 5 says they both spouses uh, going into the new marriage must agree to raise the children Catholic. Why is that? Um, the reason is that in this realm of favor of the faith, like the name says, you're asking for a favor. You do not have a right to the Pope dissolving your first marriage. So since you're asking for a favor, we're going to be more exacting in requiring the children to be raised Catholic. So very, very interesting discussion there. And Kennedy talks about that on 136 of his article. Okay, the next provision of Potestas Ecclesiae, Article 6, we're still in the substantive norms. We'll get to the procedural ones in just a moment. Article 6 says you only really get one bite at the FF apple. You really can only petition once for, you can try maybe if you think you have the great second case. But once this has been granted to you, for one thing, again, it's a favor. It's not a matter of right. And it just seems to be perhaps something unseemly of someone getting a whole series of these dissolutions. So our rule is going to be just one petition. Okay, Article 7 discusses our famous Fresno cases. And again, what's a Fresno case? Let's see if you can see that. That's in Potestas Ecclesiae, Article 7. Remember what a Fresno case is. That is one where there's a marriage that actually takes place in the church between a Catholic and an unbaptized spouse, and there's a dispensation from disparity of cult, obviously. Otherwise, the Catholic could not marry the unbaptized person. So what happens in a Fresno case? If a Fresno spouse wants to petition, if it's the Catholic spouse, then the Catholic spouse is petitioning for dissolution of the first marriage, wants to enter a second marriage. The new marriage of the Catholic has to be to a baptized person. Otherwise, the petition will not be granted. What if it's the other spouse who asks? It's a Catholic married to an unbaptized person in the first marriage. The marriage breaks down, and now the unbaptized person wants to petition for dissolution. That's okay. That unbaptized party can petition under favor of the faith, but he or she must intend to be baptized, must have the intention to be baptized if he or she wants the favor of the faith dissolution. Okay. Let's see. Article 10, this will be the last article of the substantive norms, and here Kennedy discusses it on 139 and 140. It says sometimes you're petitioning for a favor of the faith dissolution, but there's also doubts about the validity of the marriage. And Article 10 just says that if that's the case, you need to inform the congregation that there is this doubt, so that they know this. They might think that it's better for you to do a nullity petition rather than favor of the faith. So just if there is a doubt about validity, it must be disclosed. Okay, now we're going to part 2 of the norms. Again, we're still in Potestas Ecclesiae. We've just done part 1, the substantive norms. Now we're going to talk about part 2, the procedural norms. Remember, this is an administrative case. We talked about how there are some judicial cases We usually think of judicial cases when we think of marriage cases because that's what the formal process is. But there are also several administrative cases. And Article 11 of the procedural norms talks about this, and it says that it's actually the diocesan bishop who instructs the case. Now, he doesn't really usually do this personally. He usually appoints an instructor to do this for him, and really actually appoints a commission, an instructor, a notary, and a defender of the bond, so that they can examine the case, and then the instructor can give an opinion and send it to the bishop. Kennedy at 141 gives a sample decree for how the bishop would set up this commission. So the tribunal is not deciding this case. It's this commission that the bishop sets up. However, the key person on the commission is the instructor, and the bishop may choose one of the tribunal judges for the instructor. So even though this is not a tribunal case, one of the tribunal judges may be involved. And a defender of the bond and notary are involved, and they may well be tribunal personnel. Okay, Article 12 lists relevant documents, and Kennedy discusses these at 142 and 143. What the main thing mentioned here is that the respondent has to be cited. The respondent has to be informed, look, your former spouse or your spouse is trying to have this marriage dissolved. If you want to be heard on this question, you're going to have your opportunity. So that's Article 12. Also, Article 12 says that the full proof, kind of convincing proof, cannot be attributed just to the parties' declarations. We're not just going to, for instance, on the question of whether there's baptism, whether both spouses were baptized, whether they lived together after baptism, we're not just going to take their words. What they say has to be corroborated for the case to be convincing enough that the Pope will grant a dissolution. So here we're talking about the standard of proof. And so here our standard of proof is moral certainty. This is not just probability, but it's a higher standard than probability. Probability would just say, well, it's more likely than not that they were unbaptized or that one was unbaptized, so we can grant the favor of the faith. What these norms say is, no, it's not just enough to say it's probable. You have to be more certain than that. We're going to require moral certainty. What that means is there is no prudent doubt. No prudent doubt of our certainty that either one of the spouses remained unbaptized, or if eventually both were baptized, there was no consummation after that. Pius XII talked about this standard of moral certainty in his 1942 address to the Roman Rota, and it's quite a famous Rodal address. So if you happen to be interested in Rodal addresses or in this type of jurisprudence, that would be one of the key Rodal addresses, probably of all time, to take a look at. Okay, Article 14, again, we're still in the procedural norms. It talks about how the examination is done. Really, the key person is the instructor. The instructor will examine the parties and other witnesses. A notary will be present, and a defender also will be involved in the process and will be allowed to participate, probably encouraged to participate, and may attend the examination. However, only the instructor will ask the questions. If the defender has questions, he or she will submit them to the instructor. Keep in mind, and one of these articles, I forget if it's McCormick or Kennedy, says that sometimes it will be the pastor who's appointed as an instructor. So keep that in mind. You could be involved in a case in this way. We have a list of possible topics of examination, and I've got the list, at least part of it for you. What is the instructor looking for? Well, he's interested in baptism. Did at least one spouse remain unbaptized? Second, the marital history of the parties, especially what was the cause of the breakup of the marriage. The third party is the third party, especially if it's somebody who the petitioner wants to marry. Is that third party the person who broke up the marriage? What about reconciliation? Is there any hope that you still might reconcile with the first spouse? Um, Cohabitation after baptism. This is especially important if both spouses eventually were baptized. Usually, in the favor of the faith case, it's an unbaptized person plus a baptized person who are married. But sometimes the unbaptized person becomes baptized. That's okay, but for favor of the faith to apply, the there must be no consummation after um, after the second baptism. So, and if you live together, we're going to assume there was consummation. Now, you can disprove that. So that's a presumption. If you live together, we're going to presume that there was consummation. You can rebut that presumption, but if you don't have evidence to rebut it, then the presumption will hold up, and the commission will conclude that there probably was consummation. Then next question, attempted marriage. Which of the spouses, did either of the spouses attempt marriage before this favor of the faith decree was granted? And what are the religious practices of the parties? Why do religious practices matter? They matter because they might indicate whether there has been a baptism, especially of the second spouse, assuming one baptized spouse went into the marriage. Some dioceses have a questionnaire that they use for these examinations, so you may or may not have access to that. Article 15, again, of the procedural norms, is for declaring that the respondent is absent. As you know, we try to give the respondent the chance to participate in any proceeding. Usually they do not participate. If they decide not to, or they just don't answer, then Article 15 lets the instructor declare that the respondent has been given a chance, but has not wished to participate, and so is being declared absent. That's just to show that we protected the rights of the respondent. Article 16 is about the absence of baptism, and what it simply says here is that we need moral certainty. If this case depends on the absence of baptism of the second spouse, then, and what I mean is by the second spouse is, let's say it's a Christian who married an unbaptized person. I'm calling the unbaptized person the second spouse. That if the case depends on that person remaining unbaptized, we need moral certainty that he or she remained unbaptized. Again, it could be a different type of case. If they were baptized, the case can still potentially go forward, but then you have to show non-consummation. And that's what Article 17 talks about, consummation. Let me go back to 16, though. How do you get to moral certainty to show there was no baptism? We said it's not enough just to get the declarations of the spouses. We need some circumstances that show probably there was no baptism. If we show that this family that the person came from practiced no religion, that would be important. That would show that it's unlikely that there was a baptism. If the parents had a habit of not baptizing because they wanted children to decide later in life whether they wished to be baptized, that might be another circumstance. Some alienation from religion might be a circumstance to show, okay, this family probably did not baptize their children, so this spouse who's involved in this favor of the faith case probably was not baptized. Consummation of the marriage, we just talked about that. If they live together after baptism, we'll presume consummation, but if you have evidence, you can rebut that presumption. Article 18 just says we need to know the cause of the breakdown, who's responsible for the breakdown of the marriage, and we're going to see that to see if the petitioner is entitled to ask for dissolution. Article 20 has to do with the raising of children. We've already talked about that in connection with Article 5 of the substantive norms. Article 21 concerns intention to receive baptism. Remember, that's if we're talking about a Fresno case, if the unbaptized petitioner wants a favor of the faith declaration, he or she must intend to receive baptism. That's provided in Article 21. Article 23 is when the case is pretty much wrapped up. The instructor has a conclusion, has an opinion, or not so much has an opinion, but all the evidence is present. Then the instructor gives the case, gives the acts, ACTS, the acts of the case to the defender so that the defender can see everything and can see the instructor's report or draft report, and then can make his or her own observations and any points that he or she wants to make. Then it's given to the bishop. This is Article 24, and the bishop gives his opinion. Remember, we talked about moral certainty. For the case to, we need moral certainty that the circumstances, the conditions for favor of the faith are satisfied. Both the instructor needs moral certainty, and so does the diocesan bishop, who's going to be recommending, or we hope, if it's our parishioner, we hope the diocesan bishop will be recommending dissolution, recommending that the Holy Father dissolve the marriage. So the bishop gives his opinion. That's Article 24. And Article 25 says that you need 3 sets of all the documentation, and it gives you the order that you should assemble them in. So that's really the end of the norms. I just have one more point. The types of forms that you would use for a favor of the faith case are found in Coal and Westman at pages 286 to 348. What does that page range tell you? Remember when we talked about Pauline privilege, we had about 11 pages of forms. With favor of the faith, we've got about 65, almost 65 pages of forms. That is going to tell us maybe that favor of the faith cases are more complicated than Pauline privilege. I think that's true, but another reason for there being so many more pages of forms for favor of the faith cases are that there are just a great number of scenarios where favor of the faith might be available, where dissolution in favor of the faith might be available. With Pauline privilege, we're really talking about a specific fact situation, maybe a couple of fact situations. With favor of the faith, if you satisfy the 2 conditions, there are a lot of different scenarios where you can satisfy these 2 conditions. Number 1, original marriage was non-sacramental. That can be a marriage between 2 unbaptized persons or between 1 baptized and 1 unbaptized. That's going to be one difference from favor of the faith. And then, remember we said in Pauline privilege, it only applies if one spouse remains unbaptized. With favor of the faith, even if the other spouse gets baptized, so eventually they're both baptized in the marriage that you want to dissolve, the case can still go forward as long as the marriage is non-consummated after it becomes sacramental. So we're just going to have more fact situations. Again, I'd really encourage you to look through those forms. I think they would give you some real familiarity with what kinds of things are going on here, and just the breadth of fact situations where favor of the faith might apply. Thanks very much.